Thanks, Riccardo. Well, good morning, everyone, and welcome to this Cornerstone webinar put on for you by members of the Housing Team, entitled Homelessness Appeals, Assessing the Merits. I'm Kelvin Rutledge, and I'm joined by my colleagues, Sarah Salmon and Riccardo Calzavara. This is a presentation in three parts. I will begin speaking about early consideration. Riccardo will then follow with correctly discharging the main housing duty, and Sarah will complete the presentation with common grounds for appeal. And this will be followed by a short opportunity for questions. Cornerstone Chambers puts on a full program of webinars and presentations, so please check our website for details. Now, around 2 years ago, I gave a presentation to colleagues in Cornerstone on the spread of housing work in chambers. And I think we're all surprised to find that almost 1/3 of our total workload consisted of Section 204 homelessness appeals. This high level of challenge and the impact that it has on local housing authorities, on the legal aid budget, and on judicial resources was never the intention behind the Housing Act 1996. In fact, if any delegates who, like me, can remember were in practice before the 1996 came into force, the only legal means by which a homeless applicant could challenge a homelessness decision was judicial review. So therefore, in those cases where the local authority did not operate an extra statutory review procedure, there was consideration by a High Court judge of the decision of a frontline officer. And the effect of the 1996 Act was to impose two statutory steps or stages in between. The first, of course, was a legal obligation on the local authority to review certain decisions. And the second was a new jurisdiction, albeit one borrowed from judicial review proceedings, conferred upon the county court. And the clear expectation at that time, perhaps in hindsight a little naive, was that most homelessness disputes would be resolved at the review stage, and that only comparatively few would trouble the courts, and then only on pure and important points of law. Now, the proliferation over the ensuing decades of Section 204 appeals, in my view, owes less to the increase in homelessness, although that is unquestionably a factor, but more to two other factors. The first is the increase in specialist housing solicitors who are seeing and bringing more challenges. If a Martian were to read the Housing Law Report, they may feel that certain local authorities make poorer decisions than others because they're challenged more frequently. That, of course, is not the case. That simply reflects the fact that there are more solicitors in the area overseeing and challenging decisions. But I think the second reason for the increase in Section 204 appeals is the expansion of public law grounds for challenge. So nowadays we can add to the Lord Diplock classic formulation of illegality, rationality, and procedural impropriety such grounds, and we've seen these played out in Section 204 appeals up to and including the highest appellate courts, such as Article 8 of the Human Rights Convention, the Equality Act 2010, and the Children Act 2004. Indeed, it's right to say that Section 204 has been in the vanguard of development of the public law over the last 2 decades, as the law reports show. That said, Section 204 appeals are generally bad news for local authorities. They're time-consuming, they're expensive. Generally speaking, the most the local authority can hope to achieve on a Section 204 appeal is to come away with its decision intact and only have to pay its own legal costs. The flip side is that its decision is quashed, requiring further officer time and a fresh decision, or varied, imposing a duty on the local authority and a liability for both sides' costs, potentially running to tens of thousands of pounds and even more if there is a second appeal to the Court of Appeal. Added to that, there's no pre-action protocol procedure for Section 204 appeals and no permission stage that we had in judicial review. So with all those matters in mind, it makes very good sense for local authorities to have procedures, clear and effective procedures in place, which enable them to take an early and informed view of the merits of any Section 204 appeal, in order that they can decide at that early stage, before substantial costs are incurred, whether it's one that they should fight or concede or attempt to settle in some other way. And it's for that purpose that this webinar is intended. So if I can now turn to the slides, I should say in advance, these slides were not prepared by me, but I'm very grateful to accept them. That is to say, except one slide, which I think my colleague Andy Lane prepared, which is a very attractive looking slide, but unfortunately doesn't come with an explanatory note for me to be able to speak to it in this presentation. But apart from that, I'm very grateful for everything I've received. I'm going to start off, if I may, with slide number 4. So that's the one there. Thank you very much indeed, Riccardo. Next slide, please, said Chris Whitty. Introduction and the appeal test. So the things that the local authority needs to be aware of right at the outset, and I know that most, if not all of you, understand these things because local authorities are, generally speaking, quite expert, very expert in dealing with these matters. But the things they need to focus their minds on at the early stage is when they receive a 204 appeal is, firstly, does it show proper grounds? Does it raise a point or points of law properly so called? Now, it ought to. Cramp and Hastings, all those years ago, said that the grounds of appeal should be succinct and clear, but that's not often the case. Frequently, the grounds are lengthy and sometimes impenetrable. So, but it's really important that a local authority understands the case it has to meet in order that it can take a decision. And I believe that since this is litigation, where the appellant will expect the local authority to pay their costs at the end of the day, right at the earliest stage, if it's not clear what the ground or grounds are, then the appellant or the appellant's solicitors should be pressed to explain them. In the past, I've used Part 18 of the Civil Procedure Rules for seeking clarification of the grounds. And remember, Part 18 doesn't only apply to statements of case, it applies whether or not the matter is contained or referred to in a statement of case. So in my view, grounds for appeal fall within Part 18. In any event, as a matter of the court's discretion when it comes to remedies, and certainly in relation to costs, it may be a relevant consideration that the appellant has been a little shy in coming forward with the grounds. So the first thing is work out, does this case raise a point of law properly so called? Secondly, of course, this is an area which is regulated by time limits to bring the appeal. And although the court has a power to extend those time limits, that is a power which has to be exercised within the confines of the statute and on good public law grounds. So is this appeal within time? And then thirdly, assuming that you are seized of an appeal which does appear to have merit, you may not agree with it, but if it does raise a point of law, or at least purport to, and is within time, then it's important to get to grips with it and ask yourself whether this appeal is one that we should fight or find another way of resolving. So if I could move, please, to my slide 6, what with the judge. That's Andy's very, very helpful, attractive looking slide that I'm not going to speak to, but this one here I shall. And what this slide does helpfully is it just reminds us of the sort of things that will be in the mind of a judge. So we're still at the early stage. We've got the Section 204 appeal on our desk. We're looking at it, but we're thinking, what would a judge think of this looking forward? How would a court receive this? Is this one that we think is likely to be allowed? So the rules are pretty straightforward. It's for the appellant to make good the grounds. It's never the case that the matter goes to the court and the judge says, right, local authority, satisfy me, your decision is lawful. There's a presumption of lawfulness. So the burden is clearly on the appellant. Secondly, the point I've already mentioned, that the agenda for the appeal is set by the grounds. Crampton Hastings, goodness me, it was all those years ago that we did Crampton Hastings, but it's still good law and is helpful to cite to show that there is procedural rigor must be applied to this area of law. The slide then mentions the possibility of strikeout. This is theoretically possible under CPR 3.4. You can strike out any case that doesn't disclose a case in law or legal merit, or you can strike it out for failure to comply with a practice direction or rule or whatever. Strikeout's going to be difficult in the 204 jurisdiction, unless it's just obviously a complaint about the facts, and one that cannot reasonably be seen as a challenge on a point of law. But I suggest those cases are going to be fairly few and far between. We know there's a very strong body of authority now supports the view that it's judicial review in the county court. So the court must therefore not enter the decision-making arena. It must pay deference to the local authority. It must understand that the local authority is best placed to make decisions. We'll come back to this in due course. About the importance of having officer input in contesting the appeal, officers with their expert and unique knowledge of local conditions and matters like that. And finally, of course, just to bear in mind that as it is a quasi-judicial review jurisdiction, the remedies are essentially discretionary. The word is may in section 204, subsection 3, not must, although the courts will generally grant a remedy if illegality or point of law has been established. That's not invariably the case. And the Ali and Nessa and Newham case is a helpful guide there. We could turn next slide, please, Riccardo. I'm conscious of the time, so I'm just going to, we've set out a number of propositions in our slides, which you will be able to reflect on after the presentation. The message I want to get through in this first stage is the need for early consideration. There are strict time limits, as I say, they're set out on the slide here. They're imposed on the local authority for reviews, and they're imposed on the appellant for appeals. Next slide, please, Riccardo. Thank you. These are two very helpful decisions that we've set out here, Stanley and Welling, and Milton Keynes case, because what they show is that where a local authority misses the deadline for review, the situation is not necessarily hopeless. So if a local authority carries out the review and promulgates that decision after the 56-day period, it's not invalid as a matter of law. It's still a decision. But the appellant has the option under section 204 to go against the original decision or the review decision, or indeed a combination of the two. And helpfully, these cases show, Court of Appeal level, that the court seized of that appeal may well have regard to the later review decision. Now, there may be cost consequences here, and it's a point that has to be considered within the bounds of reasonableness, so that if the local authority was months late in its review decision and turned up with a review decision pinned to its skeleton argument, that may not be well received. But certainly if it's a comparatively short overrun of the review period and the local authority has carried out a thorough review, it's well worth putting that review decision forward because the court under these authorities is entitled to have regard to it. Now, the next couple of slides are dealing with extensions of time, but I want to proceed to my last slide, which is entitled Early Merits Review, really just to bring us back to, before I hand over to Riccardo, to this essential point, the importance of an early consideration. The high courts have said that considerable deference should be paid to the local authority. We're all familiar with the Holmes-Morehouse doctrine, but cases like Pochdale and Kensington and Chelsea do make it very clear that judges do have to understand that Parliament imposes these obligations on local housing authorities, and local housing authorities are uniquely placed to know whether somebody is living in suitable accommodation or not, or whether they're vulnerable or not, or whether an act is intentional or whatever, or certainly they're best placed to do that. And so that's why it's really important at the earliest stage to get the officers together, understand what the challenge is, understand how the local authority can meet that challenge. So what are the steps? One, take an early view on the merits. Does it raise a point of law? Are the time limits complied with? What relief is being sought? Is it a viable appeal? Are we going to fight it? Are we going to concede it? Is it a procedural flaw that we can repair in some way? And then, assuming it is a viable appeal and one that we are going to contest, decide on a litigation strategy. How are we going to fight it? What line are we going to take? Do we need to consider putting in any evidence? Live evidence is very rare on 204 appeals, but witness statements are often used. And at that early stage, you start putting the case together. At that point, you should be able to take a view as to whether this is likely to be a successful appeal or not. If it's a successful appeal, then the decision can be taken to fight it. If the view is it's unlikely to succeed, then it will be sensible to see whether it can be conceded or settled or resolved in some other way. Thank you. That's my part of the presentation. We're now going to hand over to Riccardo, who's going to discuss the correct discharge main housing duty.
Thank you, Kelvin, for that high-level introduction to homelessness appeals. I'm going to hone in on one particular ground of appeal that I'm seeing repeatedly cropping up, which is that the authority has erred in thinking that its main housing duty has been discharged, or that it's erred in identifying the basis on which it's apparently discharged it. Those are important questions, and I thought it might be helpful to have a refresher. The issues are complicated and technical, but getting it right is the difference between stopping a ground of appeal before it gets off the ground and trying to respond to a ground that is near impossible to defend. In other words, we can make this easy for ourselves. Once the main housing duty arises, it only ends in one of 8 ways, and those are the 8 ways in the bubbles on this page. I'm going to go through them quickly as I can. The first way is that the duty ends if the applicant refuses an offer that isn't made under Part 6 and isn't a PRSO. So this is primarily for cases in which the applicant refuses an offer of temporary accommodation. But in order for that discharge to arise, there are various hurdles the authority has to surpass. The first is that it must inform the applicant of the possible consequences of refusal or acceptance and of the right to request a suitability review. The possible consequence of refusal is that the duty will be discharged. There is no possible consequence of accepting the offer, but as is normal, an accepted offer, the applicant will be expected to take up occupation. The second hurdle is that the authority must be satisfied that the accommodation is suitable. The third is that the applicant must refuse the offer. So to be clear, accepting it does not cause discharge under subsection 5, even though the authority has to inform the applicant of the consequences of accepting. And the fourth step under this first means of discharge is that the authority must inform the applicant that it regards the duty as being at an end, which is another way of saying that it doesn't come to an end automatically. In a case called Maswaku, it was enough that the offer letter, so not a separate letter that had been sent after refusal, warned the applicant that if she refused the offer, the authority's duty would come to an end and she would have to find her own accommodation. For the more diligent among you, that's at paragraphs 52 and 53. The second way the main duty comes to an end is if the applicant ceases to be eligible. Eligibility, as you'll see from the slide, is governed by section 185 and by the 2006 regulations. And it's basically for those who are subject to immigration control. The third way is that the applicant becomes intentionally homeless from the accommodation, that's the word to emphasize, made available for his occupation. It seems to me that that means the authority has to have actually made accommodation available for the applicant's occupation. It's not enough to be homeless at home in the Airways sense. The test for becoming homeless intentionally sends us to section 191 and putting to one side good faith. That means an act or omission in consequence of which a person ceases to occupy available accommodation, which would have been reasonable to continue to occupy. And you've got the note there on the slide to section 176, which tells us the circumstances in which accommodation is available. Whether it was reasonable to continue to occupy is likely to cause the most difficulty, and unfortunately, I can't give you a shortcut to that. It requires close attention to the circumstances. And the last thing to think of in relation to intentional homelessness generally is Haley and breaking the chain of causation. The fourth way of discharging is that the applicant accepts an offer under Part 6. So to be clear, although I hope it is already, you can't discharge under this subsection if an applicant refuses an allocation. So far, so straightforward. The fifth way is that the applicant accepts an offer of an assured non-shorthold tenancy. So this is likely to be an offer from a private registered provider of social housing. And again, the offer must be accepted under this means of discharge. It's not good enough that the applicant has rejected or refused the offer. The sixth way, I think, keeping my counting right, is that the applicant otherwise voluntarily ceases to occupy as his only or principal home the accommodation made available for his occupation. This is presumably to fill the void where a person ceases to occupy accommodation, but is not to be treated as being homeless intentionally. I don't know of any cases under subsection 6D. It may be that the other speakers do. And the important thing to draw from this is the imputation of the only or principal home test and authorities, which there are many. The seventh is another of the multifaceted means by which the main housing duty can be discharged. Step one is that the offer must be of a Part 6 allocation. Step two is that it must be a final offer, and final for the purposes of this means of discharge means that it's made in writing and states that it's final for the purposes of the subsection. It's not necessary, says Rahnara Begum at 27, to recite the exact wording of the subsection. And the information does not all have to be contained within a single document, as long as it's communicated, and that's Vilva Rosa at 21 to 23. The third step is that the authority must inform the applicant of the possible consequences of refusal or acceptance and of the right to request a suitability review. That mirrors the means we looked at under subsection 5. The fourth step is that the applicant must refuse the offer. So what we see here is a squaring of the circle from subsection 6C, which arose when a Part 6 offer was accepted. The fifth step is that the authority must be satisfied that the accommodation is suitable for the applicant. And Hajjaj at 70 reminds us that it's for the authority to satisfy itself, not for the applicant to set out the reasons that the accommodation is not suitable. And the sixth and final step under this subsection is that the authority must be satisfied that the applicant is able to bring to an end any obligations in respect of his existing accommodation before being required to take up the offer. That's in subsection 8 at the bottom of that slide. It's also worth noting two important cases, Omar and Birmingham and Ravichandran and Lewisham, in which there is a discussion as to the authority purporting to comply with subsection 7, but not managing to do so. And it has been held that in some circumstances, that will be, in any event, a discharge under subsection 5. And that's important because subsection 5 provides a sort of catch-all, something for local authorities to look out for when they're faced with a ground that subsection 7 was asserted by the authority, but has not, on the facts, apparently been made out. And the eighth and final means of discharge relates to PRSOs, private rented sector offers. First, we need to understand what they are, and that leads us to a number of steps. So step one, a PRSO is an offer of a fixed term, assured short hold tenancy of at least 12 months duration made to the applicant in respect of accommodation that is or will become available. And there's no statutory limit on when the accommodation might become available. In Zaman, the Court of Appeal held that the landlord does not need to be identified to the applicant to whom the offer is made. Step two, the offer must be made with the approval of the authority in pursuance of arrangements made between the authority and the landlord, which arrangements are entered into, and this is the quote, with a view to bringing the authority's duty to an end. The third step is that the authority must inform, this is becoming familiar wording, the applicant in writing of the possible consequences of refusal or acceptance and of the right to request a suitability review. The fourth step is that the applicant must accept or refuse the offer. So we're in that category of acceptance or refusal rather than just one or the other. And I think that means that this is the only provision whereby refusal or acceptance gives rise to a cessation of duty. In all the other cases, there are different subsections dealing with refusal on the one hand and acceptance on the other. The fifth step is that the provision applies to cases that are not restricted. So we need to consider what restricted cases are. Those are cases in which the authority would not be satisfied that it owed the main housing duty without having regard to a restricted person, and a restricted person, as you'll see from the slide, is defined in section 184 as being a person who is ineligible, subject to immigration control, and does not have leave to enter or remain, or whose leave is subject to an NRPF condition. So we're back into questions of eligibility. In a case which is not restricted, the authority must inform the applicant in writing of the two effects under section 195A, and you see the relevant text on the slide, of a further application to an authority, so not to the authority, within 2 years of accepting a PRSO. The first is that priority need is irrelevant on that reapplication. And the second is that expiry of a Section 21 notice makes a person homeless rather than merely threatened with homelessness, which would be the provision under Section 175. The lead case is Norton. The relevant parts of the judgment are 43 and 56. The applicant has to be told of both effects. Step 6, the authority must not approve the PRSO unless it's satisfied that the accommodation is suitable. And step 7, a PRSO cannot be made unless the authority is satisfied that the applicant is able to bring to an end any obligations in respect of his existing accommodation before being required to take up the offer. And that's identical to the provision we've already looked at in respect to Part 6 offers. It's worth saying that, as with the Omar and Ravichandran cases I mentioned a moment ago, Griffiths at 42 to 44 provides that there may be cases in which an offer that fails to comply with subsection 7AA, so PRSOs, in any event gives rise to discharge under subsection 5. And finally, although I'm not going to go to it in any detail, reapplication is governed by subsection 9. The important cases with which everyone will be familiar are Fahia and Rika Begum. If the facts are exactly the same, there is no new application. These are, as I'm sure has become apparent from my part of this talk, very technical provisions. And save for the circumstances outlined in Omar and Griffiths, it seems to me that the black letter needs to be complied with. So it means that it's very important to be very clear about the bases on which the duty can be discharged, and in a particular case, the basis on which it is said to have been discharged, to attempt to stop at least one indefensible ground of appeal. And that leads me to Sarah, who will be talking through common grounds of appeal.
Thank you, Riccardo. It's always impressive when a barrister keeps to time. I'm not going to have to rush as much as I thought I might have to. I'm going to have a look at some common themes and grounds that we are seeing in Section 204 appeals. But first, and if we can go to the first slide, Riccardo, please. It probably goes without saying that in terms of prospects of success in defending any Section 204 appeal, it's generally only going to be as good as your review decision. And one thing in my mind that ultimately will assist you in assessing the merits, will assist counsel in assessing the merits, and will assist the court ultimately if it ends up before them, is how a decision letter is set out. Reviewing officers really should try and avoid unnecessary length, repetition of issues, and any unnecessary complication. The lengthier a decision, it's fair to say, and the more legal provisions, if it's overly legalistic, if I can put it that way, will give rise to potential grounds, inconsistency and error. And often it goes further than the duties required by the reviewing officer to give reasons. There's a number of cases, older cases, that deal with sufficient to enable the applicant to understand why a decision is made against them and assess whether there are reasonable prospects to challenge the decision. So that's what reviewing officers need to bear in mind when they are crafting their decision. It's easy to see how it happens, lengthy and overly complicated decisions, because it often happens when there are solicitors involved in the other side and you're having to deal with representations made by them, which are often pages and pages and pages long. So it's not a criticism, it's just trying to refocus and come back to basic principles, how you set out your decision. If it is a particularly complicated decision, or actually probably for any decision, think about a simple structure. Now, sometimes it's all about keeping your tribunal happy, and I'm going to steal His Honour Judge Luba KC's pet hate on this. Please use paragraph numbers. I say this quite a lot, but I still see review decisions where there aren't the use of paragraph numbers, and just having paragraph numbers will enable anyone trying to assess the Section 204 appeal to easily refer to paragraphs where things are dealt with or handled, and you want to keep your tribunal happy, and it's something judges. Keep your sentences clear and short. Identify the relevant issues at the beginning. Isolate them and address them. Now, you do have to bear in mind that in relation to some things that you consider, for example, suitability, you look at things and you have to look at that full assessment as well, the composite assessment. So some thought needs to be given to that, but try and isolate the issues and address them. Identify the law and the guidance that is applicable to each of the issues raised. Not too much law. If you put too much law in, I think sometimes that's where local authority decisions can become a little bit unstuck. Identify, and if it is necessary because of the type of decision you're taking, determine what the material of your decisions, give your reasons, and then don't return to the same issues again further on in your decision, except if you're summarizing and you're looking at fundamental parts. It's an issue I think I frequently see. I don't know if Kelvin and Riccardo agree. The issues are just repeated on and on. So in this slide as well, I've set out some common challenges and errors. Riccardo, can we just go to the next slide? Now, I do have a bubble slide, and I am going to quickly speak to it. This is just setting out what I'm going to be addressing under this section. So first, I'm going to look at an aspect of the procedure. I still see in most of the Section 204 appeals that come across my desk a challenge relating to deficiencies and irregularities in the original decision and the alleged failure to comply with the provisions, in particular in relation to what commonly called minded to letters. That, in my mind, should be a relatively simple challenge to avoid. So we're just going to have a quick look at that. Second thing I'm going to be looking at is suitability, but with the focus on the out of area offers, with the pressures that we see now on the availability of accommodation within local authority areas. I am seeing more and more of these suitability challenges coming across my desk. Sort of thirdly and fourthly, I'm going to deal with inquiries and how to handle medical evidence. Now, despite these two issues being dealt with and quite well established in terms of the case law, most appeals that I see throw these issues in. And sometimes they're easier to defend, sometimes they're not. So I'm just going to go through those. And then on the last slide, I've just included a list of recent Section 204 appeals, both from the county court, which I always think is helpful to look at and see how your local judges are dealing with Section 204 appeals, because a lot of the time, the merits may well come down to the law, but the merits may also come down to, but I know this county court judge has made this decision in another case. And so that needs to be borne in mind. And some from the higher courts as well, just to highlight what we're seeing. So moving on to the next slide, we start with our minded to letters. Now, about the 2018 regulations and that they govern the procedure on review. And as I've already highlighted, the focus of this talk is on Regulation 7, but really Regulation 7, subparagraph 2. That, of course, is the part that says if a reviewer considers there is a deficiency or irregularity in the original decision or in the manner in which it's made, but is nevertheless minded to make the same decision, which is against the interest of the applicant on one or more of the issues, the reviewer must notify the applicant that they are going to do that and give the reasons why, and allow representations to be made. That can be orally, in writing, or both. And there have been a wealth of cases in the higher court on this regulation or the previous regulation in the 1999 regulations, but it's exactly the same really in terms of its wording. And they are set out under the second bullet point on the slide. I don't have time to go through all the cases, but we all know it is widely construed, and it can include things or events that happen following a decision. So they probably aren't even addressed in the original decision because they've happened afterwards. So those are the banks and the NJ cases set out there. And whilst each case is likely to turn on its facts, it's also been held to be engaged where an applicant has said on review that she was actually confused when she rejected an offer of accommodation, and she didn't really understand, she said, the number of offers that she would be able to receive. And that was a case of Mahmood and Birmingham City Council. And the Court of Appeal essentially said that because her position was not manifestly unsupportable, the reviewing officer should have invoked the proceedings. Now, that is a case to me which demonstrates how wide the regulation can be construed by the courts, and it is what a reviewing officer and anyone assessing the merits of a ground like this should bear in mind. And before leaving this slide, which is sort of a general slide, before I get into some of the issues we're seeing at the moment in relation to Minded 2, if there is any doubt, or if you've got a particularly litigious case, the solicitors keep writing lengthy representations to you, or it's a particularly complex case, just send a letter would be my advice. Kelvin's already dealt with Regulation 9. I've obviously just said you need to bear in mind the sort of time limits in terms of review procedure when you're looking at whether or not a Minded 2 letter should be sent. So moving on to the next slide, I'm just going to highlight two grounds that I'm seeing at the moment based upon the regulations. Now, the first one is dealt with on this. A reviewing officer gives an applicant to respond to a Minded to Find letter. Now, the second case on this slide is one of mine. You can't find the written judgment on the internet. I do have a copy of it, and it was handed down in the summer this year. And the first one is one that I found on Nearly Legal, which is a good place to go and find your county court decisions in relation to these matters. And we can see the contrast of approach that's been taken in these two county court cases. So just looking at Tapper first, this was His Honour Judge Parfitt sitting at Central London. And a Minded 2 letter was issued on the 17th of March. Representations were requested by the 28th of March. In that case, when you look at the note that's been put on Nearly Legal, you will get a sense that actually the review had taken an awfully long time. And what had actually happened was the applicant had asked for an extension to make their representations to the 1st of April, which had been refused by the review officer. In any event, the applicant's representations were provided first thing on the 4th of April, and the review decision was issued in the afternoon, but the reviewing officer decided not to consider the representations. So just pausing there, if you get representations in late, it's probably worth just taking a step back and taking stock and seeing whether or not they should be taken into account, even if your set deadline has passed. And what His Honour Judge Parfitt said was the question he had to determine was whether the appellant was effectively deprived of the right to respond to the Minded 2 letter by the procedure which the reviewing officer had insisted upon. And he clearly found she had been so deprived and said that in the circumstances of that case, the bare minimum period for the response should have been 14 days. Now, in contrast, moving on to the case where I acted for the London Borough of Bexley, it's slightly complicated by the fact that the ground failed primarily because I was successful in arguing it wasn't actually a minded to letter under the regulations. What had happened in that case is the reviewing officer had decided there was not a deficiency or irregularity in original decision, but decided to send a letter saying, this is the decision I'm going to make. Do you want to make any representations? But within her review decision letter, she had set out why there was no deficiency and irregularity, and the letter wasn't headed up, as we often see, as a regular letter. So primarily we won on that point. However, can we move on to the next slide, Riccardo, please? The judge did basically set out reasons for why she thought the amount of time given, which was a very short period, it was the 7th of October to the 12th of October and included a weekend, as to why she decided that was enough time in this particular case. Now, what the other side were trying to argue is there are some time periods given in Regulation 5(3)(b)(2) of the 2018 regulations. That's the regulation that's headed up requests for a review and notification of review procedure. And the particular time limit is 4 days in circumstances where the effect of the notice given is to bring the authority's duty to the applicant under section 1952 to an end. And the appellant was trying to argue that that time limit essentially should be imported into regulations. You can see from the slide that the judge rejected that argument. These two cases don't mean that such arguments are going to stop there. And there isn't obviously a time period given in Regulation 7 itself. So the reason I've flagged this is reviewing officers and those assessing the merits will need to be alive to the fact in the courts. Can we move on to the next slide, please, Riccardo? This is another common ground that I've been seeing for the last couple of years, actually, and it hasn't stopped. I've got this quite a lot in quite a few 204 appeals, which is that there should have been another minded to find letter. So the reviewing officer sends out the first one, representations are made, the reviewing officer goes on to make its decision. And the argument is that if there are any new facts or circumstances raised on the representations in response to the first minded to letter, another one should be sent. Now, touch wood, I have not had a case in the court in which I've acted for a local authority where the applicant has succeeded on this point. Most of the cases I've dealt with haven't actually been new facts or circumstances. It has just been a response that may mean the inclusion of a new document that's put before the reviewing officer, but it's actually all from the same facts and the same circumstances. And the appellants in the cases I have haven't tried to take it further, or if they have, they haven't got permission. I'm not aware that this point has gone up. And you'll see from the slide that the again is quite an old case now, back in 2005, that it isn't the absolute rule that the applicant is entitled to the last word in every. So that's a case I often will cite when I'm answering this ground. But again, it's a point that's being taken, and it's a point that may well end up going up, which is why I flagged it, because reviewing officers should be alive to the fact that this may be it. And I am aware of one case where His Honour Judge Letham did out an appeal on this point on the basis of new material from an occupational therapist after a minded to letter. Now, that was a case where the applicant's circumstances were very sympathetic. There was a very disabled young child involved as part of the household, and the local authority who lost that case didn't want to take the case any further. So again, they've just allowed His Honour Judge Letham's decision to stand. So it may well come back in the future, and it may well find itself between the higher courts on the right facts. Now go to the next slide, please, Riccardo. Now I have to rush because I'm running out of time. Just straight to the next slide, please. Thanks. So one of the other things we're seeing a huge rise in at the moment is suitability challenges where it's out of area. On this slide, I've included one of the most recent cases, which is the Webb Harden case. Now, the court was considering suitability through the prism of the public sector equality duty in section 149 of the Equality Act in this case. But if we can go to the next slide, Riccardo, it's paragraph 40 of the decision, which I think may well be helpful for those looking at the merits of a case just to go to, because it gives a long list of what the court said the reviewing officer considered, and on the basis of all of those considerations, the local authority, were able to resist the challenge and the appeal was dismissed. So it looks at things like the impact of moving so far away from an area, of accommodation, the ability to travel between London and Warsaw, and so on and so forth. And the court ultimately said that the reviewing officer had carefully considered and formed a view on all the disadvantages that were said to result from moving a person, such as the appellant and her family, from London. So it's a good case to go to just to have a look at what was considered. The next slide sets out a number of cases, which I'm sure you're all aware of, some more recent than others. We obviously start with the Zalamezo there. And I've just set out some key takeaways in relation to these cases when you're looking at the merits of any decision that you've made. Now, we all know from the Zalamezo that local authorities should have an operator published policy, both for procuring sufficient units of accommodation and also a policy for allocating those units to the individual households. If the policy is lawful and it's followed and you can demonstrate compliance, you're in good shape to try and resist one of these appeals. Many of the cases that have been successful for the applicants have succeeded because either there's no policy or the policy hasn't been followed, or importantly, the authority cannot demonstrate that it's followed its policy. Now, whether that's on the housing file or in the decision letter itself, you have to demonstrate that you're complying with your policy. You don't have to give chapter and verse on every internet search you've made, every single property between where they're living and the place you're offering. You don't have to do that, but you do need to make sure your decision indicates why accommodation is not being offered in the area and why any accommodation is available in the area. And finally, within those bullet points, you'll see it goes back to the Webb Harden case that you consider all representations that have been made and considered, and the impact of the entire household on a move. And this is sometimes I see where things can fall down, is there's sweeping statements like the children are not of important key stage, they're not at an important key stage level, they can move schools. But if you have a family where there are specific educational needs, you need to take slightly more care in how you go about that and how you make your inquiries and how you think about the impact of a move. So it will depend on the circumstances. On the next slide, and finally on suitability, I've just included a county court case where the local authority was said to have ignored evidence of need. It was a need for 2 bedrooms. The medical evidence all said that, and His Honour Judge Monty KC allowed the appeal. I'll let you all have a look at that in your own time. Again, it's from Nearly Legal website. The next slide and the next 2 slides look at inquiries and medical evidence. I am out of time. You will all be aware of the duty to make inquiries. They don't have to be CID types inquiries. But one thing I just want to draw out very quickly is at the moment we're seeing, or I'm seeing, I had one within the last couple of weeks, this idea that there's a heightened of inquiries where the public sector equality duty is engaged. Now, in Bidden and Waverley Borough Council, which is on the last slide, that was a case where that that point was taken. And the Court of Appeal said, in relation to a heightened duty due to the PSED, there was no statutory basis for such contention. You can see that at paragraphs 54 and 55 of the decision, but it's still being run despite those cases, and it's still being run on the same basis that you saw in Waverley. So it's still something that medical evidence, it's ultimately a decision for the review officer. Decisions still fall down where a local authority has taken medical advice and the review officer simply adopts what the medical advisor has said. That's not what should be happening. You need to look at all the medical evidence in the round and come to your own decision. So those are the sort of grounds that I see most often and are seeing most often. The final slide, as I indicated at the beginning, just sets out a list of relatively recent decisions from all kinds of courts, so you can see the types of things that are being argued in front of the county courts and also the higher courts. And right at the bottom there, you can see the Waverley case to which I've referred. I think, has Riccardo been answering questions? I think there's a couple of questions.
I've been trying to, yes. I'm just typing away furiously.
Furiously typing answers. I don't know if you want to deal with any of them live just quickly before we go.
I'm so far through typing that I won't. I will carry on typing before we close up.
Okay, so Riccardo is going to answer all of your questions on the Q&A function. I'd like to thank everyone for coming and thank my co-speakers. I'd also like to thank Andy Lane and Dean Underwood, who were original speakers for this webinar, and some of their material has been used in the creation of these slides. So shout out to them, and we hope this has been useful. Thank you very much.
Thanks, Sarah. I'd like to just add to that. Thank you very much. And thank you, everyone, for your attendance and for your continuing support for the Chambers. And I say, do please check our website for further events. Thank you. Goodbye.